Kenya has a Witchcraft Act. Under Section 7 of the Witchcraft Act of Kenya, it creates an offense that says, any person who employs or solicits any other person to name or indicate by the use of any non-natural means any person as the perpetrator of any alleged crime or other act complained of shall be guilty of an offense and liable to a fine not exceeding 500 shillings or to imprisonment for a term not exceeding 5 years. So what does witchcraft and employee discipline have to do with each other? This is V for Verdict with me, James Wanjeri, and today on our employment law discussion, we deal with a case where witchdoctor was called to an employer's premises to establish who had stolen from the employer, and the evidence of the witchdoctor was used in determining the employment dispute. What did the court say about this? Now, perhaps you have to start by saying that when you look at the Constitution of Kenya, it envisages a society in which the culture of constitutionalism and the rule of law is ingrained, that it is the norm rather than the exception. The Constitution also provides for settlement of disputes through alternative channels, or what we call alternative dispute resolution methods. Now, we also have what we call the alternative justice systems, that people can present themselves to alternative systems where they can receive justice, and this includes the barazas. This even includes going to the religious leaders to have their disputes resolved. However, the employment relationship is a very dynamic one, and it can often be subject to the preferences of the parties to it. But when dealing with an employee dispute, employers and employees have to know that there are very specific processes that must be undertaken, and there are some paths which, while they may be taken in other areas, they cannot be allowed in the employer-employee relationship. Today we are highlighting the case Civil Appeal number 64 of 2020, the case of PN Mashru Limited versus Ouma Ojenge. And in this case, the Court of Appeal was invited to determine whether the use of witchcraft in resolving employment disputes is an acceptable method. This matter was an appeal from the decision of the High Court in Mombasa. And in that decision, and by the High Court, of course, I mean the Employment and Labor Relations Court, because they are the same level. So the Employment and Labor Relations Court had issued a decision in favor of the employee, and the employer then went ahead to file the appeal seeking to set aside that judgment of the Employment and Labor Relations Court. According to the employee, he had been employed from December 2011 to 15th May 2014 as a spray painter, and he was earning 16,000 shillings a month. He claimed that though he was entitled to an additional sum on salary as house allowance, that was never paid to him. He was then dismissed on allegations that he had stolen a computer box. According to him, this allegation was based on the results of the rituals performed by a witch doctor whose services had been retained by his employer. As a result, he was arrested by the police and detained at the police station overnight. The following day in the morning, he was released from custody, but his employer dismissed him from employment. He sought legal assistance, and upon the intervention of his legal team, the employer made an offer to him for his return to work. However, the employee declined the offer and instead opted to be paid his terminal dues. The High Court, in assessing the manner in which he had been terminated, found that his termination had been unfair and gave him compensation equivalent to 4 months' salary. But the employee had also demanded for punitive damages, and punitive damages are awarded as punishment, especially where a defendant's conduct is considered to be so serious. It's serious misconduct, and it's also used as a means of deterring other defendants, the defendant and other defendants, from such conduct or such behavior in the future. The Employment and Labor Relations Court held that the resort by the employer to the use of witchcraft violated the employee's rights to fair labor practices, which are protected under Article 41 of the Constitution of Kenya, as well as Section 41, 43, and 45 of the Employment Act, and therefore that action was repugnant to justice and morality, which was inconsistent with the Constitution and the law. In respect of punitive damages, the court found that based on the mode of investigation that had been adopted by the employer, the claim was merited, and the judge awarded the employee 450,000 shillings as punitive damages. In the appeal, the employer challenged the finding and argued that the award given was extremely high and it was oppressive to them. Now, the Court of Appeal began by finding that in Kenya, punitive or exemplary damages are awarded under only two circumstances. Number one, where there is oppressive, arbitrary, or unconstitutional action by the servants of the government. Or number two, where the defendant's actions was calculated to procure him some benefit, even though it may not necessarily be financial, at the expense of the plaintiff. So, of course, we know the plaintiff is a person who takes the matter to court, and the defendant is a person who has been taken to court and needs to respond to the case. The third scenario is, of course, where the Act of Parliament or a law specifically authorizes for such damages to be paid out. The employee argued that the actions of his employer in procuring a witch doctor to investigate the loss of items at the workplace not only succeeded in instilling fear in the employees, but also resulted in the exit from employment of some of the employees, and by extension, it afforded a benefit to the employer due to those exits. The Court of Appeal, while finding fault with the employer's approach, stated the following. They said, in this case, we must ask ourselves what the appellant, the employer, intended to achieve by resorting to the unorthodox method of investigation by engaging the services of a witch doctor. Such unconventional and unlawful action, undertaken by a sophisticated entity, aptly described by the learned judge as not a gullible simpleton, a village outfit, but a major enterprise resident in the resort city of Mombasa, must have been intended to achieve more than just vindicate a court of justice. In those circumstances, we agree that the appellant intended to derive some benefit from its action by resorting to wizardry, as the learned judge termed its action. The court had first to look at the status of the employer, and it says the employer is not a gullible simpleton. It's not a village outfit. The employer was actually a well-established enterprise in the city of Mombasa. And therefore, by resorting to this action, they could not have blamed that on ignorance, or they could not have blamed that on simplicity. They knew what they were doing, or they ought to have known what they were doing. Now, the Court of Appeal had been asked to reduce the punitive damage. The Court of Appeal said, in this case, there is no doubt that the employee was subjected to the indignity of undergoing rituals in the hands of a witch doctor. The employer's action was not only criminal, but it was also demeaning, contrary to Article 28 of the Constitution. In the circumstances, we find no reason to interfere with the award. Therefore, what he had been issued in the Employment and Labor Relations Court was upheld. Now, of course, this is a classic case of the use of solutions that offend both the law and societal expectations. How do employers then ensure that your organization does not resort to such tactics? Under the Employment Act, when undertaking disciplinary action or even when undertaking investigations, you have to remember to always observe the law. Article 49 of the Constitution of Kenya is clear on what rights a suspect has. It's clear under Article 50 on the question of a fair trial. So, of course, in employment circles, you first have to begin in the event that you're undertaking disciplinary action by issuing a show cause. After the show cause has been responded to, you then move to the next step, which is the disciplinary hearing. That disciplinary hearing, the person is given an opportunity to hear the case against them. They are then allowed to have a fellow employee present or a union representative, and they can also bring in their witnesses and challenge the witnesses of the employer. So it's important that they are given all the evidence that will be relied against them. Then the disciplinary tribunal makes its decision and communicates it to the employee. If it's a termination, then a termination is issued. If it's a warning is issued. And if the employee is acquitted, then those charges are set aside. That is a process that is recognized under the laws of Kenya. And so, I hope your organization will not be caught engaging witch doctors to determine what has happened or to try and obtain evidence. This is V for Verdict with James Onjeri. Thank you for joining us.